All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Morning, Council. The Court now calls case CV1426. This is Dale Schaub et al. Versus Nefra, Inc. This is the time set for oral argument. Council, let me advise you that today's proceedings are being recorded and they're also being downloaded to the court website, which means in about 24 hours they will be available. I believe it's on YouTube, so be mindful of that. You both have 20 minutes for your arguments. The appellant, you can certainly reserve time for rebuttal if you wish to do so. Keep in mind that we have a clock in front of you so you can keep track of your time. We have read everything. We've read the briefs. We've discussed the case, so we're very familiar with the issues. With that being said, counsel for the appellant, Mr. McGill, is it?
Yes. Good morning.
Good morning.
I would like to reserve 5 minutes, Your Honor, if I could, at the end. If the panel would focus initially on Exhibit 1 to the appendix, which is the transcript of the proceedings. There was an initial hearing conducted on April 23rd, and Appendix 1 of my periodical shows that transcript, Your Honor. And since the court has indicated that the panel has reviewed the pleadings and is familiar with the case, I will not exhaust time going through a summary of the case because Your Honor has just indicated that you have done that. There's essentially 3 points that I'd like to make this morning, Your Honor. And the first is the importance of advocacy, a client's right to counsel to have zealous and creative advocacy within the bounds of the law. And
I was going to say the state bar has removed the term zealous, has completely removed at the last radiation of the ethical rules.
Very well, Your Honor. In 2013, this was the context in which I found the case, if I may. And as I understand it, Your Honor, according to the U.S. Supreme Court, and the case is Operative Engineers versus AC Company. It's 859 F. 2nd, 1336. It's a Ninth Circuit case, 1988. That's Operating Engineers. 859 F. 2nd, 1336. In that case, that's a U.S. Supreme Court case. Justice Stevens held.
With an F second, say?
F second. That's a federal. I'm sorry. That case, Your Honor, I stand corrected. That's a Ninth Circuit case which cited Talamini versus Allstate, and that's the U.S. Supreme Court case, 470 U.S. 1067, 1985. I stand corrected, Your Honor. In the Talamini case, Justice Stevens pointed out that Rule 11, or sanctions, the courts should be very cautious and very reticent to issue a sanction because attorneys, as part of their job in representing their clients, are to enthusiastically pursue factual and legal theories in a case. So, Judge Portley.
The word is actually diligently now, isn't it?
Yes, well, diligently. Okay, now let me put this in context, because if you go to the transcript, Exhibit 1, when you go to that transcript, if you would go to page 41, it's page 41 and 45 are the two key pages. Because when I researched this issue, this motion for a creditor bond, this is the reason that I asked the commissioner if I could brief this. Because even though I believed I had a sufficient basis under the statute, and I'll get to that in a moment, to file or seek relief under ARS 12-1375. Even though I believed I had a good faith basis for doing so, given the context of the case, which I'll get into in a moment, I thought that the best practice was to ask the commissioner in court whether he would grant leave for me to do so. In fact, when you read page 41, and I'll just read it for emphasis, it's on line 3, McGill, and Your Honor, we ask for a creditor bond in case there's a wrongful garnishment of the stock. Are you refusing to order the corporation to do that? So I had asked for a creditor bond at the hearing on page 41. In other words, and that's an important nuance, Your Honor, I had asked for the creditor bond at the hearing before the commissioner. And then he said, and this is very important, he said, and help put that in context for me. So he was asking for context for that specific motion, that request, which made sense to me. He's asking for context. And I'm thinking at the time, on behalf of my clients, and my client, he had a cardiac arrest, had short-term memory loss, we alleged in the underlying case, which is still going on. The underlying case, there's no trial judgment in this case. That's important, too, from a procedural standpoint. There is no trial judgment, even today. But when I spoke to Commissioner Morrow,
Judgment is there?
the only judgment that was in the case, Your Honor, was this discovery judgment based on a protective order that arose out of the counterclaim that Mr. Oslin filed. And that was the context I was going to get to in a second. I'll jump back to this transcript in one moment to answer your question fully. That was a $12,000 discovery judgment based on the counterclaim that was filed. The counterclaim alleged, we believe it was just filed to block us as a defense tactic. And it was quite successful at that because recently I filed a motion to supplement the record under RCAP 11 because Judge Cunanan at the trial in September of 2013 threw out the counterclaim at trial under Rule 50. There was no proof of liability or damages. And this is the context under which I had this hearing before Commissioner Morrow. This is what I was faced with as an advocate, Your Honor. I've got a client that's filing a lawsuit after most of the money was taken out of the corporation. So we filed in 2010. We immediately get hit with a counterclaim. I review the counterclaim and it says, and I've attached the counterclaim portion to the appendix. The counterclaim is based on divulging confidential information. And nowhere in the counterclaim is there any specificity as to what the confidential information is. And I still, to this day, don't know what it is. And neither did Judge Cunanan, so he threw it out at trial.
But there was a judgment for
There was a judgment.
$12,000-something dollars.
Yes.
And it wasn't appealed. And that's what they were seeking to execute.
Okay, well,
right?
that's true. There was a judgment. It was not appealed. But that judgment, I believed, based on the context of that counterclaim, that it was specious, that it was utterly groundless and borderline, it was in bad faith and fraudulent. Okay, that's how bad it was.
But it was final, wasn't it?
Well, it was final, but final judgments may be attacked later under Rule 60 if they're based on fraud or oppressive conduct. I researched that at the time, too.
That's certainly true, but they're good judgments until you challenge it with Rule 60, right?
So here was my thinking back to the hearing, Your Honor, to address where you're going with that. My thinking at the hearing on April 23rd, 2013 in front of Commissioner Morrow, I read the statute. I know the statute says that you can pursue a creditor bond if there's no judgment. That's what it says, no judgment. Number one, judgment's not defined in the statute. Number two, I had researched that area. And given the time constraints here this morning, to condense it down to this. There were two cases, one in 1969 and one in 1970. The two cases were, let's see if I can find it. One was the Nettles case. Nettle, Arnold versus Nettle, 10 Arizona Appellate 509. And the other was Andrew Brown Company versus Painters Warehouse, 11 Arizona Appellate 571. Those two cases essentially said that a debtor cannot attack a writ of garnishment on a writ of garnishment through a motion to quash the writ. You have to file an independent action, and then right after those two cases, the legislature came in with 12-1573 because the garnishment law is statutory. So the only remedy a debtor has if they believe that the creditor is trying to attach assets that have a value that exceeds the amount of the judgment, which jeopardizes the debtor in a sense. It impairs them because they're attaching assets that are valuable, much more valuable than the judgment. The only relief you have is 12-1573. That's it. So I go into this hearing with the commissioner and I'm thinking, all I've got is 12-1573. There's no trial judgment. The underlying case is still going. I believe that the counterclaim, which led to the protective order and the $12,000 discovery judgment, was infirm and potentially fraudulent. Turns out when we fast forward, the trial judge agreed there was nothing there, no proof of liability or damages, and threw it out. So we go to page 45 very quickly. Commissioner Morrow asked me to put it in context. So we go to page 45 and I say, that's the intent. And then I said, but I don't know how the events are going to unfold in the future. All I'm suggesting is hopefully that all that happens. I hope it does. That is their good faith intent. This may all be moot because of that. But all I'm suggesting as an advocate for my clients is anytime I've seen a creditor try to move against an asset that has value that far exceeds the judgment, the court orders the creditor to bond it in the event there's a wrongful attachment. And then Commissioner Morrow on line 17 says, most certainly I will allow your client to file supplemental briefing by May 15th on that issue. And I'm talking about a creditor bond. There's nothing else I'm talking about. He allowed me to file it. There's no other way to read this. And then what he did, on September 6th, he issued a minute entry. If you go to the appendix, it's September 6th, Exhibit 18 in the appendix. He issued a minute entry on September 6th, 2 weeks before the trial, or 1 week before the trial. And he said, well, what I meant was that I wanted you to do a supplemental briefing on the status of the garnishment. First of all, you do a memo on the status. You don't do supplemental briefing on the status of something. That's number one. Number two, the transcript speaks for itself. I relied on what he said. So I filed. Number three, the judgment, the discovery judgment, Judge Thompson, was stayed because my client bonded it. That affected their resources in the case. So did this counterclaim business.
It was the garnishment that was stayed, right?
That garnishment judge, the discovery judgment, the protective order, which arose out of the counterclaim, that judgment was stayed. It was bonded and stayed by my clients.
Not just the garnishment.
Not just, well, the garnishment, that stayed the garnishment. The bond on that discovery judgment on a protective order
It
stayed the garnishment, correct. But the point is, in the context of
Still a
12...
judgment.
Right, it's still a judgment, but it's stayed and it's rendered ineffectual because it's secured and stayed. They can't execute on it.
Right.
So I thought,
Still wanted a creditor's bond.
well, I wanted a creditor's bond because I was telling Commissioner Morrow, I'm saying, Your Honor, I'm asking for I wish he would have just denied it at the hearing. I said, I'm asking for a creditor bond. Are you denying that? He said, no, put it in context. I put it in context, then he said I could brief it. So I filed a motion on it. It's that simple. I wish he had just said no. We wouldn't be here today. That is not fair to the plaintiffs, with all respect, Your Honor. It's just not fair. And it's just not fair to me as an advocate either. Now, the other thing is, when there's plain language in a, please let me know when I've got 5 minutes,
You
Your
got
Honor.
23 seconds before 5 minutes.
Before 5 minutes? The other thing is that then the commissioner vacated 2 hearings. In the June minute entry, he had a hearing set. The day before he vacated it, issued the sanction. Later, he said, I was inclined to grant a hearing. This is in November. You can look at the minute entry. And he said, I was inclined to grant an evidentiary hearing, but I've decided that would not be helpful. And this is after my client had submitted a declaration saying that he directed that I filed the motion for creditor bond as opposed to myself. So under 12349B, which says that the court is to make an allocation between the client and the attorney, at a minimum, there was that issue for an evidentiary hearing, and Commissioner Morrow said he was inclined to have the evidentiary hearing, and then he vacated that hearing a second time and said he didn't think it would be helpful, even though that allocation issue is there. So that's the due process problem. I'll come back and reserve my 5 minutes.
All right, thank you, counsel. Mr. Oslin?
Thank you, Your Honor. The issues in this case are not nearly as convoluted or undecipherable as Mr. McGill makes them. This is an appeal from the denial of a motion for new trial. Very little of what Mr. McGill had to say about his opinion concerning the manner in which the original judgment that we were executing upon came into existence is actual or factual. Would you like me to correct the record, or do I need to do that?
Well, I guess taking a straightforward view of the case, there was a judgment, you sought garnishment, and then a bond was posted that apparently stayed the garnishment.
Correct.
And there was this question as to whether you can get a creditor's bond when there's already a judgment. But if I understand the appellant's argument, it is that he was sort of sandbagged into repeating his arguments that the judge or commissioner later got upset about.
Let me go to that issue right now then. As a preamble.
In other words, I'm not
Okay.
confused about, but that seems to be what the rub is.
As a preamble to that, let me just mention to the court that I read the Desert Palm case that was released from this court on the 15th, and it clearly talks about the standard of review for this case. That's CACV 13-0376. It was filed on the 15th of January, 2015. Paragraph 37 says, we review for an abuse of discretion the Superior Court's denial of a motion for new trial or remediator. And then it cites a couple of cases for that proposition. So what we're looking at here is did Commissioner Morrow abuse his discretion in denying the motion for a new trial, not any of the rest of this stuff. Mr. McGill says if the judge had just denied his first motion, and remember his first motion was filed a day before the hearing we're talking about, the transcript we have here, filed it on April 22nd, and it specifically included a request for the court to appoint a creditor's bond for the same general arguments that you've heard here today. That's a day before the hearing. And he said, gee, I wish the judge had just denied it, because if he denied it, we wouldn't be here. On April 23, 2013, the judge did issue a minute entry in connection with that hearing. And it's in part of the record, and I'm sorry, I didn't look at the index number on this particular one, but it's an exhibit to the appellant's brief. And the last page of it, the court says, later, the court is aware that prior to the hearing of the court's, or learning of the court's order to expedite the hearing to April 23, 2013, on their motion for stay of execution filed on April 10, 2013, debtors, that's Mr. McGill's clients, debtors filed on April 22, 2013, a second motion to expedite motion for stay and request for creditor's bond. Given the court's ruling on April 10, 2013, given the court's ruling on the April 10, 2013 motion for stay of execution, the April 22, 2013 motion is moot. So when he received this minute entry, and presumably read it because it's underlined in other parts and it's part of his exhibit, so the underlining must have come from him. He knew that the April 22nd motion had been denied as being moot. It was no longer in play. Now, Mr. McGill has also said, gee, I got sandbagged. I asked the judge, could I file this thing? And he said, surely, I'll let you do that. I got sandbagged is the effect, and using your words, I think, Your Honor. But
Well, more elegantly, he's saying that he filed the supplemental brief at the request of the judge, essentially.
yeah, but let's read further on the pages that he cited to you, because he only cites a piece of these things. Exhibit 4 to my answering brief contains the entire context of that transcript. And let's start at, he read as part of page 45. Let's go on a little bit further on that same page. At line 17, the court, most certainly I'll allow your clients to file supplemental briefing by May 15 on that issue. Mr. McGill, thank you. The court, if your client, well, let me see if May 15. Now, on the other hand, if they don't post the bond, we probably will be back here earlier to lift the stay well before that deadline. But just so your clients are aware, your clients can post for the hearing on that issue by May 15 if they see a need to do so. I am not, Mr. McGill, thank you, Your Honor. The court, seeing that there's, and just so you're aware, I'm not ordering them to spend money post the briefing or to file that briefing. Mr. McGill, I understand.
And if I understand, at that point, the commissioner was waiting, expecting that a bond would be posted that would make the garnishment. It stayed.
Correct. And that's what Mr. McGill had told the judge at the earlier hearing and confirmed again in direct response to the judge's inquiries at this hearing.
Right, so
it was the expectation, but
the judge's mindset was, well, I may have to reconsider this creditor's bond if they don't post the bond that protects their assets.
that was always a possibility.
But in fact, the bond was posted, right?
It was posted, yes. But bear with me and let's continue on. We were at line, well, let's start again at line 3 of page 46. The court, seeing that there's, and just so you're aware, I'm not ordering them to spend money, post that briefing, or to file that briefing. Mr. McGill, I understand. The court, and I'm not going to slow down the execution on the garnishment pending that briefing. It sounds like since the asset we're talking about would require a sheriff's sale, we've got plenty of time between now and then, and when a sheriff's sale occurs to brief whatever issue you want. I do not know if that would be a wise expenditure of your client's money, but how do you, Mr. McGill, it may include it, yeah. The court, how you want to spend your client's money, Mr. McGill, I appreciate that, Your Honor. The court is up to you. I submit to you, if you read the entirety of the transcript, Mr. McGill was not ordered to file his brief. He was really not even encouraged to file the brief. He was told that the statute he was relying on didn't apply to this situation because we had a judgment, and the statute he was relying on is pre-judgment, and Mr. McGill ignored that, as he's pretty much ignored it here today. It's not a trial
Wasn't the
judgment.
court telling Mr. McGill, let's see if you post the bond. If you post the bond, it's over, it's moot. But if you don't, I may need some additional briefing. Isn't that the context of his statement?
I think that,
In fact, the bond was posted,
yes.
and so that was the signal.
Well, and that should have been the end of it, shouldn't
Is-
it? As you understand both the court's logic and Mr. McGill's logic? But it wasn't the end of it, was it?
Are you asking for a ruling from the bench here from me, or?
Well-
I'm teasing you, counsel.
I know you are. Look at the rest of the record. Instead of dropping that issue when the bond was posted, because the judge had told him it would be moot when the bond was posted, he continued to pursue it. He continued to ask. He continued to ask under the same authority that doesn't apply. It doesn't apply whether or not he posted the bond. Excuse me, bonded around the judgment. Yes,
Do you
Judge?
think there's a misunderstanding as to the judgment he's thinking about? You had a judgment that wasn't appeal. That's a unique judgment, as opposed to the judgment he may have been thinking about of the overarching case.
No, it was very clear which judgment we were talking about.
Well, I know. I think the record is clear, but I'm just trying to understand, at least your understanding of Mr. McGill's thinking and continuing.
Mr. McGill's thinking has always been that he was going to win this case. He's lost it. There's one issue that still remains to be decided by the judge. All of the briefing has been entered. In fact, we had the last evidentiary hearing on it October 31st last year. We're waiting.
What issue is that that's left?
The judge removed from the jury the issue of declaratory judgment, declaratory relief. And the judge has come up with a creative theory that because the parties no longer can get along with one another, notwithstanding there's no statutory authority for it, he's going to order the two individuals that were defendants in this action to purchase, or maybe it's the corporation, to purchase Mr. Schaub's stock. For what amount, we don't know. That's what we're waiting to find out. And based on what authority he is ordering this, he's already told us it's not a judicial dissolution and it's not a stockholders derivative or stockholders' rights, dissenters' rights kind of case. That doesn't apply. But nevertheless, he's told us he's going to have either the corporation, must be the corporation because the individuals aren't involved in that part of it, have the corporation purchase Mr. Schaub's stock for some unidentified amount. And while we're talking about Judge Kinanen and some of his orders, Judge Kinanen denied Mr. McGill's request to vacate or strike or cancel the protective order that was asked for at or before the trial, and it was denied by Judge Kinanen. It's in, I think, in the first day minute entry of the trial, September 6th or thereabouts. So what we have here is a final judgment, 54B language, a year old, never been appealed. We're trying to collect on it. We're asked, Mr. McGill's clients asked for a stay and for a creditor's bond. There's no authority for the creditor's bond, but there is authority for the stay. The judge grants the stay. The garnishment is stayed pending further activity, and that's the conclusion of this case, so that we know whether they...
Now, the authority for the stay was the likelihood that the debtor would post the bond?
Oh, yes, sir. The stay was predicated entirely upon the creditors posting the bond. And, of course, that's creditors' rights, and we have no quarrel with that. We had no quarrel with it at the April 23rd hearing, as the court can read from the transcript. But what we did have a quarrel with is this idea that just because the judgment debtor has to post a bond to stay execution, that somehow or other the creditor, judgment creditor, is supposed to have to post a bond as well. Tit for tat type of thing. And Mr. McGill wouldn't let go of that. He filed motion after the judge ruled asking that to happen. He filed a motion for reconsideration. He filed a motion for a new trial. And the judge found, as I believe he correctly found, that that was an expansion of the record, a necessary expansion of the record. in sum, I support the award and the decisions of Commissioner Mora, and I think his minute entries contain sufficient explanations and findings of facts and conclusions of law. There is no question of law in this case. The statute does not require a judgment creditor to post a bond as a condition of garnishing anything. But yet that was the argument made by Mr. McGill. And I appreciate his attempt to say, well, gee, I was just trying to be creative and I've got a duty to represent my clients diligently. But there's a line beyond which you're not supposed to go. And that's why 12-349 is there, that if you do exceed and cross that line, you get your hand spanked for it. And that's appropriate. Sanctions have been entered in this case once before because of the conduct of Mr. Schaub and his counsel, not because of us, as is clear from the Rule 37 judgment sanctions. And it's consistent with what happened here in the garnishment proceedings. They were unnecessarily and improperly expanded. Do you have any further questions of me, Your Honors?
No, counsel. Thank you.
Thank you, Your Honor.
Mr. McGill?
Very quickly, Your Honor. The first point I want to clarify is that when I had that discussion with Commissioner Morrow, he had indicated later in the transcript he was ruminating about whether we would post the bond and stay the action, and I didn't know if we would. My motion was for a creditor bond. In other words, we stayed the judgment, and I felt that was an additional ground to go in with the motion for creditor bond, which under 12-1573 it says if there's no judgment. As Judge Portley indicated, there was no overarching underlying trial judgment. The trial was a couple months away. The discovery judgment was stayed by the bond that my clients were posting. And what I asked Commissioner Morrow on page 45, it couldn't be clearer. Counsel just obfuscated it. All you have to do is read page 45. I specifically asked him if I could brief a motion for a creditor bond. That's exactly what I said twice on page 41 and page 45. It couldn't have been clearer to me. And he said, yes, of course you can. By May 15th, I said, thank you, Your Honor. Then he went on and ruminated about our bond. That doesn't change what he just told me I could do. We're talking about a different bond. The bond I'm trying to get is a creditor bond. Even if we bond it, my client, the debtor, bonds it and stays the case. I want a creditor bond because I believe the counterclaim is bogus and fraudulent, which Judge Cunanan threw out at the trial. We still have a major portion of the case that has not been decided, so they haven't won. The core of the case was the valuation of the stock. That has not been decided yet. So that was misleading to the court. But I wanted
A judgment's a judgment. It doesn't, although it's becoming clear based on your argument that you're looking at the overarching, they still had a judgment.
Well, they had a judgment, but it's,
and
yes, Your Honor.
54B language.
Absolutely. But as an advocate, I looked at that. I looked for a definition of judgment. Does that mean a final judgment? Because the way...
No, well, the courts don't care. A judgment's a judgment.
But Your Honor, with all due respect, if a lawyer could not contest language in a statute, no statutes would ever be overturned. Brown versus Board of Education, statutes, cases, we're here to try to challenge the interpretation given language in a statute. But
Brown wasn't a statute. Brown was a Supreme
Court case. That's true. But what my point is that the philosophy is that a lawyer, if he sees a term that's not defined in a statute, he has a right to challenge that.
You bet.
Okay, the last part I want to get into is, so that transcript is crystal clear, and he made a decision, we moved on, and he's ruminating about something else. He's ruminating about our bond, not the creditor bond.
Counsel, he's asking you, or he's telling you, but if you post the bond, then this will be a moot point, because the purpose of the bond is to be for the amount of the judgment plus
Right.
principal and interest. Your whole purpose, you've said, is for the creditor's bonds to make sure they don't over-collect. But if you've posted the bond, the bond takes care of it.
I'm glad you
just
said that.
forfeit the bond.
Let me explain that very briefly, because I want to cover one other major point. But let me explain that. even though when we post a bond, that moots it or protects our assets on this overvalued stock, stock being greater. I agree with that. But our thinking was, we want a creditor bond from them pending a trial on the merits, because we believe the counterclaim that caused that $12,000 discovery judgment was infirm, fraudulent, and could be set aside under Rule 60. If that gets set aside, we have a claim against them for a wrongful garnishment. And we wanted to make sure that we were bonded on that separate claim.
Did you argue that to the trial judge?
That's what I argued when I filed the motion for a creditor bond. And I thought the judge understood that and allowed me to file. That's the point. There's no bad faith here. Last point, Your Honor. Forgive me. The other thing that's glossed over, he withdrew 2 hearings. One, he scheduled a hearing, and then in June, he just ruled and sanctioned both of us and withdrew the hearing on the very next day. Then he withdrew later. He said, I was inclined to give you an evidentiary hearing, but I don't think it would be helpful, even though there was an issue about whether it's the client or the party that's at fault. And my client had submitted a declaration saying he directed it. And the judge in his minute entry in November noted that and still withdrew that hearing. That's a due process problem. 2 hearings withdrawn. That's due process, separate from the transcript. The last point, Your Honor, very last point. There's 3 elements. Give me 30 seconds, Your Honor. Forgive me. I apologize.
Got 15.
15 seconds. There's 3 elements under 12349, plus there's 12350. He didn't go through any of the factors in 12350, and that's required in the cases and in the statute. And the 3 elements in 12349, subsection F, he avoided by saying it's an unreasonable expansion and it's not an unreasonable. He avoided that and got away from those elements. That's due process
I understand,
problem,
counsel.
Your
All
Honor.
right, thank you.
Thank you.
All right,
Thank you.
counsel will issue a written decision in due course. This court's in recess.